Have you ever considered how the digital age impacts intellectual property rights? In the blink of an eye, we have witnessed the world transform into a digital playground where information is shared at the speed of light. This rapid advancement in technology has brought about new opportunities but also new challenges, especially in the realm of intellectual property rights. Intellectual property rights, which include copyrights, patents, trademarks, and trade secrets, protect the fruits of human creativity and innovation from unauthorized use. In the digital age, these rights have become more complex and harder to enforce. From music files being shared across the globe in seconds to 3D printing technology that can reproduce patented products, the digital age presents a new frontier for intellectual property law. Whether you are a creative artist, an innovator, or simply a consumer of digital content, understanding these rights is crucial. With the rise of the internet, understanding these rights has never been more critical. Take, for instance, the case of Napster, a pioneering music-sharing platform. Born in the late 90s, Napster quickly became a symbol for the internet's disruptive potential. It offered a peer-to-peer network where users could freely share music files, sparking not just a tech revolution, but a cultural one too. But as the platform grew, so did the eyebrows of record companies and artists. They saw their copyrighted material being shared without permission, and crucially, without financial compensation. What followed was a series of high-profile legal battles, spearheaded by bands like Metallica and Dr. Dre. The courts ruled in favor of the artists, leading to Napster's eventual shutdown. But this was more than a simple victory for the music industry. It was a watershed moment for intellectual property law. The Napster case highlighted the tension between sharing and protecting creative content online and compelled the law to evolve with technology. Napster's case set a precedent for how intellectual property rights are upheld in the digital age. Or consider the case of Google Books, which aimed to digitize the world's books. This ambitious project was initiated with the noble intention of making all human knowledge accessible to everyone. However, it quickly ran into a quagmire of copyright issues. Authors and publishers from around the globe cried foul, arguing that Google was infringing on their copyrights by digitizing their works without permission. The resulting legal battle was a landmark one, highlighting the intricate dance between the advancement of technology and the protection of intellectual property rights. It underscored the delicate balance that needs to be struck between making information accessible and safeguarding the rights of those who create it. The Google Books case also brought to the fore the need for a reassessment of copyright laws in the light of the digital era. It raised questions about whether these laws, many of which were written in a pre-internet age, are still fit for purpose in today's tech-driven world. Google Books' case sparked a worldwide debate on the digitization of copyrighted works. So, where do we go from here? As we look ahead, the future of intellectual property rights in the digital age becomes increasingly complex. Technological advancements are happening at a rapid pace, and our legal systems are struggling to keep up. Today we see a digital landscape where creative ideas and innovations are readily shared and accessible. However, this also poses new challenges to protecting intellectual property. How can we ensure that creators and innovators are rewarded for their work, while still promoting the free exchange of ideas and information? One possible avenue is to develop more flexible laws and regulations that can adapt to new technologies. This could mean establishing new categories of intellectual property rights, or redefining what constitutes a patent, a copyright, or a trademark in the digital context. The future of intellectual property rights is uncharted territory, demanding creative solutions and forward-thinking policies. As technology continues to evolve, so must our understanding and regulation of intellectual property rights. In conclusion, intellectual property rights in the digital age present a complex but crucial issue. As we've explored, this evolving field is filled with both challenges and opportunities. The digital age has transformed the way we create, consume, and distribute content, and so it's only natural that our legal frameworks adapt to these changes. We dived into the real-life case studies of Napster and Google Books, two examples that demonstrate the intricacies of copyright laws in the face of technological advancements. Napster, a pioneer of digital music sharing, pushed the boundaries of copyright infringement. Meanwhile, Google Books, in its quest to digitize the world's literature, found itself in a decade-long legal battle. Looking forward, the future of intellectual property rights will continue to evolve with technology. It's a fascinating, intricate dance between innovation and regulation. As we navigate this digital age, it's essential to keep informed about these rights, not just as creators, but as consumers too.